Good morning, just dear colleagues. I welcome you with the opening of the work of the Third International Conference, Social Rights and Their Protection by the Administrative, devoted to the issues of the efficiency, the analysis of the court practice, and how to apply the case law of the European Court. 2020 is the very memorable year for the justice. Just we have marked the 15th anniversary on passing of the Conduct of the Ministry of Justice that became the push for the beginning of the administrative courts in Ukraine and development of their system. Particularly with that event was the basis for our conference to be organized. One of the circumstances because of COVID-19, we had to adjust our plans to change also the date of our event as well as the form of our event. The objective of our conference to share experience, knowledge, results of the scientific research, discussion of the relevant issues and the issues of the protection of the social rights. An important thing that we have involved, just we have attendees from also from judges from Germany, Latvia, Austria, Poland, also scientists and academicians from different fields which are interested in the protection of civil rights. On the whole, there are also the research to look for an ideal model because people would like to have the protection of their rights. I am certain that our conference will become one of the sites, one of the platforms to outline the tasks in this direction. And this will be useful for the improvement of the present-day administrative legal mechanism to protect social rights. I hope that this conference will become an important step in ensuring the efficiency, the protection of social rights. And now, it's my pleasure to give the floor for welcome remarks that was just taking care of the constitutional rights because of the position, because of the civil position. The president of the Supreme Court, Valentina Danishevska. Miss Valentina, you have the thanks a lot. Dear ladies and gentlemen, it's my great pleasure to welcome all you at the conference, which we devoted to the protection of social rights and the efficiency of their judicial protection in the European countries. As many of you have noticed, restrictions due to the current just lockdown, the Supreme Court does not reduce its communication on the issues of relevant issues of practice. We have conducted over 60 online events in that period with a entire coverage of over 200,000 videos, although this form of communication is not quite convenient for us, but it has its advantages because online events we can involve more participants, more attendees. Also, it's an opportunity to have more international partners to involve. An importance of the today's topic have united many partners in this platform, and I'm very thankful to all who have participated in organizing and holding these. This is the National Academy of Legal Sciences, the Institute of the State and Law, named after Koretsky, the National School of Judges of Ukraine, the project of the European Law Justice, the Office of the Council of European Union, and the RADA project, and as well as for IDPs. Also OCPCU, also a German Fund of International Legal Cooperation. You are our regular and reliable partners from the very start of the Supreme Court operation. I'm thankful for your support. As that has been noted already, we have in our conference colleagues from Austria, Latvia, Germany, and Poland. I sincerely welcome all those who have found time and opportunity to join us. For us, it's important that we continue the cooperation with the Supreme Court of Latvia. The judge of this court, Jurida Brieta, who has been the regular judge advisor in Twin Project, worked for 2 years in our Court also have joined to this conference. I welcome at our event the head of the European Association of Administrative Courts, Judge of the Administrative Court of Vienna, Mr. Edith Zeller, who is always sharing her knowledge with the Ukrainian lawyers. It's also a pleasure to hear the judge from Germany, Dr. Miriam Messling. Presently, we only start our cooperation, but I hope that this cooperation will become lasting and effective. I seem to be the judge of the financial chamber, the head of the section of European law of the Supreme Administrative Court, on Mr. Bartosz Wojciechowski, who is regular international expert of the project EU Law Justice and who is our reliable partner. And also extremely pleasant to welcome the judge of the federal court, Ms. Eva Endler. Thank you that you were able to join to this event and they would share Austrian experience in ensuring the efficiency of justice in social disputes. It's my pleasure to welcome international expert judge from Poland, Mrs. Monika Smusko. It's our pleasure also to that our judge event joined by a representative of the Pension Fund of Ukraine, deputy head of the Pension Fund of Ukraine, Mrs. Kopashka Irina Vasilievna, as well so many just employees, officers of the Pension Fund of Ukraine. For the Supreme Court is very important because a lot of cases relate to pension disputes. Also, I welcome all speakers and I thank you all speakers who have agreed to make presentations at our conference, and also all listeners, all attendees who have manifested their interest in this topic and are just taking care of the protection of civil rights. The topic of our conference is not very simple because of its social sensitiveness and because a lot of cases in this category, because of the complexity of the enforcement of the judgments. To talk it in the language of numbers, only in 2019, local administrative courts have received almost 73,000 applications on the issues of labor, employment of population, and social protection of citizens. The lion's share are complaints against binding pension insurance. It's about 50,000 cases, which is about 68% of all social disputes. It's worth to pay attention to a big number of cases relating to IDPs. Now, over 10,000 such applications were submitted to courts. Regretfully, disputes on the social protection of citizens are also relevant, those citizens that suffer from the Chernobyl disaster. The statistics analysis demonstrated that almost 9,000 applications were submitted to courts. We should also state that courts, on the first instance, satisfied about 84% of the complaints in social disputes. It's quite a high percentage point for us to talk about the huge level of the violations of citizens' rights by the state. To the courts of appeals, about 50% applications, such cases are submitted, and half of these cases are considered already in the Supreme Court. We have a separate chamber specializing in the consideration of social disputes. We have some dynamics in the reduction of the submission of the application. We should pay attention also that social cases take annually about 20% of all cases considered by the Supreme Court. We analyze the reasons for the reduction in the number. One of the reasons has been the introduction of the Institute of Model Case, which is a new case for the Code of the Administrative Justice. This institute is aimed at providing the efficiency and the unity of the case law in some categories of cases. In over 2 years, when we apply this model case pattern, but talking about efficiency, we mean first of all the improvement in the protection of the quality of the protection of rights. But most of the cases considered by the court relate to the payments of different pension benefits, pension benefits to the APs, to the servicemen, to the in offices of the prosecutor's office, etc. There are also just big numbers of the cases relating of paying some lump sums to pensioners, and also pensioners to be paid to citizens who moved abroad. And the reviewing of the cases that some provisions were named unconstitutional, uh, just based on the law on the protection of the victims of the Chernobyl disaster and the other cases. The need to protect human rights judicially underlines the importance of the topic we discussed today. So, state legal mechanisms of the protection of social rights and the perspectives for the development of the administrative justice on the protection of the social rights and the procedural means to provide for the efficiency of the justice in disputes are of great importance for the protection of human rights. We are glad that these issues will be presented by judges, by scholars, and by our international experts. Judges of the Supreme Court present new approaches, our new case law to consideration of social questions. It's very important for these stances to be understood and to serve better to the better protection of the social potential. Ukraine, for many years, is under the scrutiny of the attention of the Council of Europe, uh, which monitors the enforcement of the judgments of the European Court of Human Rights. First relates to cases Ivanov versus Ukraine, Agnomich versus Ukraine, and judgments. These judgments of the European Court does pay attention that enforcement of the judgments nationally and enforcement of the judgments of the European Court in Ukraine have face many problems and actually do not lead to real protection of human rights, even despite that there are such judgments. Most of measures to be taken by Ukraine for the enforcement of the judgments, these are measures of general character. That means that the judiciary itself is not capable to ensure fully the protection of human rights, social human rights. The solving of these problems is to be resolved by joint efforts by the parliament, by the government, and by the judiciary. We are to understand that the ensuring of the enforcement of the court decisions is our joint duty to the citizens and to the international partners, and first and foremost to the Council of Europe. The efficient enforcement of the judgments could enhance the level of confidence of citizens to the government on the whole, as well as to the judiciary in particular. Well, I'm certain that today's event will facilitate the search, the efficient decisions in this field. I myself would listen attentively presentations to be made by our foreign colleagues. I would listen to the presentations of scholars, judges, in order order in order to the result of this discussion to find additional tools, opportunities for Ukrainian citizens, and but particularly just in the field of social protection would be more protected. Thank you for your attention, and I wish you constructive work during today's event. Thank you, Valentina Ivanovna, for your welcome remarks. Thank you for your wishes. Dear participants, again, because of some circumstances, our the head of the administrative cassation suit, Nicholas Mikoch, was not able to attend, who informed about that, but he made a video recording. Now I suggest that you would see. Good morning, dear friends, dear colleagues. I sincerely welcome you with the opening of the third international scientific and practical social rights and their protection by the administrative courts. The administrative cassation in the composition of the Supreme Court is open to the constructive communication with the city, with the wide general public. Therefore, annually, with active support of our friends, partners, we organize a range just of scientific or practical events. This event is part of the third international scientific practical conference is organized with the project Law Justice, Council of Europe project IDPs, project of the Council Group, development of social rights, human rights as a key factor of the sustainable democracy in Ukraine, OCPCU, the German Foundation of International Legal Cooperation, and in cooperation with the National School of Judges, National Academy of Legal Sciences, the Institute of State and Law named after Korotsky. I would like to express sincere gratitude to our friends, and I hope that our cooperation will be constructive to, for Ukraine to becoming a democratic and rule of law state. The Constitutional Administrative Court introduced a good tradition to hold annual conferences on the issues of administrative justice, well, which is participated by renowned academicians, judges, experts, and it's very important for the present-day development of the law and informant about the case law. Particularly, this conference we conduct in the days of the administrative justice. These days have been initiated by the since it's from the period from the 20th June to 10th of July. Regretfully, the pandemic didn't allow us to do it in a ordinary time span. Therefore, we organize it in this month. The topic of our conference is is defined by the diapason, the spectrum of the issues which are important. This year, conference devoted to issues of social protection, judicial protection. The Ukrainian constitution contains several dozens of articles, but the most important of them is Article 3 that says that a human being has his life, dignity, honor, just impunity, recognized in Ukraine as the highest social values. The state is bearing responsibility for the Indeed, Article 3 of the Constitution of Ukraine gives the rhythms to the to specifies the legal direction of all articles, the which are regulating human rights, in particular social rights. the constitutional recognition that the human beings are the highest values. It means that the society and the state or other to place some events higher than human beings themselves. The, but sometimes the state ignores very often this, just ignore interests of human beings. Therefore, administrative courts are on the guard of to safeguard these interests. This is the purpose why they were established. If we look at the cases considered by the courts, particularly on social matters, which we receive, is this number is not reducing. Administrative courts take all possible efforts to ensure the availability of the constitutional values to serve just as as a protection against the bureaucrats. And I think that holding of this conference through holding this conference will be able to solve many problems that appear in resolving. On the one hand, it's a pleasure thing, but thing that many scholars say that the main cause of these conflicts in the number of cases submitted to administrative courts is the inefficiency of the legislation. That is that the parliament of Ukraine under just is not functioning properly to pass required laws. For all to understand the law should be clear just for all. Then all problems will are to be resolved. There will be less conflicts to be um, brought to courts. I sincerely hope for open dialogue, and I invite all highly esteemed participants to discuss the case law of the Supreme Court on the issues of social rights protection, and to discuss also the case law of other foreign courts. I sincerely thank particularly donors, particularly those who helped to organize this event. Well, I wish you good results in this event. Dear participants of the conference, one of the co-organizers of this conference is the National School of Judges of Ukraine, a state institution with special status in the justice system, which takes care of the special training of judges and for the employees of the staff. I give the floor to Doctor of Law Mykola Onishuk, rector of the school. You're welcome. Good morning, dear participants of the conference. It's my pleasure to welcome our international partners, foreign attendees, numerous participants from the Council of Europe, representations of whom will enrich the content of our conference devoted to the judicial protection of the social rights. The conference has gathered almost a record number of co-organizers. It's about 12. No doubt, it should be reflected also in the efficiency and effectiveness of the discussion of important questions which are in the agenda of the conference. It should be noted that conferences play a very important role, not only as a platform for discussion of some range of questions, but as a matter of fact, as to form relevant doctrine that should be embodied in judgments of courts, and of course in the judgments of the Supreme Court. That's also from the judgments of the Supreme Administrative Cassation Court. The topic of the conference is more than relevant as it relates to the protection of social rights, which is the basis of the dignity of the human life. It's not occasionally while establishing the Ukrainian state, the first articles of the Ukrainian constitution specifying the founding principles of the Ukrainian state has been named That's the state of the social type. It means that the state has undertaken a range of important constitutional legislative obligations to provide for the dignified life of a citizen. The process, which are also typical for Ukraine and other countries, to some extent demonstrate the trend to the narrowing, not to widening, of the government obligations. And naturally, under such circumstances, courts in particular should become and are on this guard of protecting the social rights of citizens. Social rights are the opportunities of citizens to be full-fledged participants of the social relations. And particularly, they do the basic subject and object of the relations and the function of the Ukrainian state. The issue of the protection of social rights, we have been convinced already in that, has aggravated and in the period of such an ordinary phenomena, it's the circumstances of pandemic related to COVID-19. It only aggravated the issues of the enhance the need for the protection of social rights. That's occasional. The head of the committee of the Parliamentary Assembly of Council on Social Youth, Health, and so Luis Reike Ramos said that fight against pandemic should be carried out with the maintaining the children. After World War II, pandemic COVID-19 demonstrated the need for the enhanced protection of social rights of people. The human right protection is the inviolable just part of that, and particularly courts play important, in this case, the administrative courts. By the way, it's necessary to point out the relevance of the topic of the judicial protection is that in European countries, separate branches of courts have been social courts have been established, and I think that our foreign participants would comment on this moment. As had been said before, the justice relating to social rights takes quite a big share of the operation of courts, and it is well known only in the cassation courts consider annually about 28,000 cases. It says that the introduction of the institute of the model case, actually pilot cases, can play a more important role in ensuring in the procedural economy and in the proper protection of social rights through administrative court, and also using proper practice in this. I fully share that. So the judicial protection is very important, but it's not the only component of proper organization of its constitutional duty responsibility to protect constitutional rights. The issue of the unity of the case law in this category of cases still remains a very important matter, and we are all hopeful that we, by taking part in our conference, that to help to develop corresponding recommendations on the proper formation. So it's also important to understand that the source of the law presently, and the source of the case law, is actually Ukraine's enforcement of its responsibility. I mean, the case law of the European Court. But not less important is, and this circumstance is not yet mentioned, social charter of Europe, which is ratified by Ukraine. That the question is about the protection of social. And I hope that based on results of the discussion and our joint activity during the conference, this problem will be also reflected in our presentation. Well, finishing my remarks, I would like to say the only to corroborate that the National School of Ukraine remains interested in will be in making our cooperation more active in holding such joint conferences. It should be mentioned that in recent years, the intensiveness of such events, the initiativeness of the Supreme Court, in particular of the Administrative Cassation Court, uh, just is improved, which gives us hope to to, to develop better standards, cassation standards for the enforcement of the debt. Dear colleagues, I would like to note that this conference is participated by the National School of Judges. We expect also to hear more about that, and we are devoted to this cooperation. I mean, the National School of Judges being part of this system of justice. I wish you constructive work during our conference. Thank you. Thank you, Mykola Ivanovich, for your welcome response. Thank you for the support of our event. Dear participants of the conference, I would like to introduce the next speaker, professional activity of whom is relating directly to the protection representative of the parliamentary ombudsman on social issues, Olena Stepanenko. Olena, you have the floor.
Thank you very much, dear colleagues. My warmest greetings to all participants and organizers of today's event. The Verkhovna Rada Ombudsman planned to be present personally during this event, but unfortunately she could not make it because she is now to be present at a different event. So I have this great honor of reading her welcoming speech to the participants of this conference. Dear participants of the international conference, the topic of this conference is extremely relevant because the effective protection of human rights is one of the main signs of the law-governed state. Article 55 of the Constitution guarantees the right to fair trial, particularly when it comes to the violation of the social rights of the citizens, particularly when public authorities do not behave properly. So the case law of the Constitutional Court of Ukraine, of the European Court of Human Rights, and national courts play an important role in reinstating violated human rights. For 17 years now, the government has failed to regulate the social rights of Ukrainians who live abroad, and we have the correspondent decision of the Constitutional Court of Ukraine. There's another one of 2018 on reinstating the benefits for citizens who survived Chernobyl accident and war veterans. So the citizens have to resort to administrative courts, which creates additional difficulties and pressures on the judicial system. The responsibility for failure to actually exercise or to fulfill those court decisions is not envisioned in the legislation. And here I would refer to the case Burmich versus Ukraine about systemic issues with the non-execution of court decisions in this country. The government established a special commission to ensure the judicial enforcement. And members of that commission represent various layers of the public administration, including executive, legislative, and judicial branches of power and the civil society. And I'm sure that this commission will consider a lot of cases and will recommend remedies for this situation. So, being the Ombudsman of Ukraine, I now observe a number of issues with the enforcement of administrative court's decisions, the main of which are as follows. Public authorities avoid enforcing court decisions, particularly when it comes to pensions. Then the need to enhance the judicial control of judicial enforcement in the order provided for by the Code of Administrative Procedure. And I, as Ombudsman, reflected this issue in my annual report to Parliament about the situation with protection and promotion of human rights and fundamental freedoms in Ukraine for 2019, with very specific recommendations to the government on how to address them. And I hope that today we will be able to discuss and identify and propose solutions to the topical issues of judicial guarantees to social rights of Ukrainians. And these recommendations will be taken on board by the government and other public authorities. Thank you very much for your cooperation, and I wish you fruitful work. Lyudmila Denisova, Parliamentary Commissioner for Human Rights. Thank you very much. And on behalf of the Ombudsman's Office and on my own behalf, I wish all of you fruitful work. And I hope that this work, particularly in cooperation with the Social Rights Chamber, will yield the expected results. Thank you very much for your attention. Thank you, Olena, for the welcoming address. Dear participants of the conference, I'm sure that you already know that the academia has joined in this conference. They participate very actively in the process of the judicial reform, of the legislative reform, and in the reform of the judicial science. So it is my great pleasure to give the floor to Mr. Alexander Petrushin, President of the National Academy of Legal Sciences of Ukraine, Doctor of Law. The floor is yours. Thank you. Esteemed President of the Supreme Court, esteemed justices of the Supreme Court, dear participants, dear colleagues from international institutions and foreign countries. First of all, I would like to thank for the invitation to participate in this conference. And I would tell you that the National Academy of Legal Sciences of Ukraine cooperates very closely with the high courts. We have got the necessary MOUs, and we have achieved very tangible results. I would like to draw your attention to the fact that today in 4 of 5 constitutions of the world, every 5 constitutions of the world, there are certain provisions on the importance of social rights of their citizens, which means that the topic of today's conference is extremely relevant and timely. It is also most difficult and complex because courts are trying to provide constitutional guarantees and social rights, but in many countries, courts are authorized to check the operation of the executive bodies of power in implementing those rights. For example, to provide medical care irrespective of the payability of the patients in South Africa, for example, in Indonesia or in India, and even in the USA. in the states where social rights have been enshrined in the constitution, courts play a leading role in providing such safeguards of social rights. Until recently, the theoretical literature has had a lot of disputes whether courts should play this role and whether it is in line with the nature of such rights and the nature of judicial protection. The new wave of theoretical research, both in Europe and internationally, is characterized by a wide recognition of the fact that courts in all parts of the world, irrespective of the level of the development of democracy and economy, irrespective of whether it is Anglo-Saxon law country or common law country or continental law country, should focus on the promoting and protection of social rights. So today, they all focus on certain narrow issues related to social rights. First of all, whether they are available to those who have financial capacity for this access to justice or to everyone. And you will know that yesterday, Ukrainian parliament introduced certain amendments to legislation to this effect. We are all very well aware that direct judicial protection cannot be the only way of ensuring the exercise of social rights, and we've heard that already from other speakers. The legislative norms should impact the interpretation of legal norms in the administration of justice. Secondly, social rights have a very important and sometimes priority role in various electoral processes. So as one of the founding fathers of the USA, Alexander Hamilton, has noted, courts often lack the force of sword and wallet. And this actually is a very realistic and very topical today, not only in this country, but in many modern democratic countries that respect rule of law. Just about 30 years ago, the two major instruments in human rights law were adopted. For example, Vienna Declaration and Action Plan, to the effect that social, economic, and cultural rights are cannot be torn away from other rights, and they are universal, they are indivisible, and they are mutually reinforcing with other human rights. So now when it comes to theoretical research and in this area, I would say that today judicial literature underscores that courts at all levels should be brave enough when it comes to the exercise and promotion and protection of social economic rights, because the countries have committed to do so. And domestic law should be in line with international standards in this area. When it comes to social and economic rights, we made the minimum guarantees that the country cannot give up under any circumstances. As we feel today, it's exactly what the case law of Ukrainian courts is working towards, particularly when it comes to the situation of today, the economic and public health crises of today. When the British students actually sued the government, arguing that the threefold increase of tuition fee actually precludes their access to education, the courts underscored two main things. First of all, they did not revoke the governmental decision, saying that it could lead to the administrative chaos in the country. On the other hand, the court stated that the business secretary of the respective ministry could not actually ensure the equality in the public sector, and they should pay special attention to the promotion of equality in the area of education. So this is yet to underscore again that this topic is extremely relevant in the context of processes underway today, but it is also equally complex given the tendencies of today. I would like to wish all of us a fruitful work, good results, and better attitude to the protection of social rights, not only by the judicial branch of power, but by other branches as well. That will allow us to improve the situation in this realm. Thank you very much, Mr. Petrician, for the welcoming address. Thank you very much for participation in this event. You will know that this event is being supported by the Office of the Council of Europe in Ukraine, and two projects supported. First of all, internal displacement in Ukraine, long-standing solutions, and then the situation with the democracy in Ukraine. Olena Litvinenko, acting head of the Council of Europe office in Ukraine, kindly agreed to participate in this event. So the floor is yours. Thank you very much, Mr. Rybachuk. Good morning, esteemed Most President of the Supreme Court, esteemed international participants, justices of the Supreme Court, dear speakers and participants. It is my great pleasure to welcome you all on behalf of the Council of Europe office in Ukraine. Indeed, we've contributed to the organization of this event within two projects. One of those is focused on the protection and promotion of IDPs, and the other on the protection and promotion of social rights. It's extremely important for us to participate in the event dedicated to the topic of protection of social rights in administrative justice, and particularly focus on international standards for the protection of social rights in Ukraine, and specifically on Ukraine's commitments as a member state of the Council of Europe, particularly when it comes to the European Convention of Human Rights and Fundamental Freedoms and European Social Charter ratified by Ukraine back in 2006. Ukraine then joined only 76 out of 98 points or provisions or articles of the Charter, which is seen as the social constitution of Europe. It guarantees the protection of social rights of any person, right to economic protection, to housing, particularly to people from vulnerable group, persons with disability, children, older age citizens, IDPs, migrants, etc. In Ukraine, the issue of social payments, their targeted nature and their timeliness is the outstanding issue. It is a sphere which is most complex and difficult, and it is in the ambit of the administrative.
Важливим, і що буде сьогодні гарна нагода обговорити практику, яка існує в Україні, а також застосування стандартів Ради Європи, зокрема положень Європейської конвенції з прав людини, практики Європейського суду з прав людини. Я б окремо хотіла б сказати, звернути увагу на те, що саме завдяки суддівській практиці реалізовуються стандарти Ради Європи з питань внутрішнього переміщення. Мова йде про впровадження цих стандартів на національному рівні, і це, безумовно, сприяє захисту прав і свобод вимушених переселенців. Так, саме зразкова справа стосовно пенсійного забезпечення вимушених переселенців заклала основу для захисту пенсійних прав ВПО. Також активно розвивається судова практика щодо захисту права ВПО на різні види соціальної допомоги, а також що стосується компенсації за зруйноване житло внаслідок збройної агресії. І важливо дуже насправді, що права, захист, розгляд цих справ і відбувається на користь захисту прав.
Consideration of these rights is being done at the backdrop of the analysis of the rights and freedoms of IDPs and the domestic case law on the issues of internal displacement and application of the standards of the Council of Europe that were developed and published with the support of the COE project in Ukraine. We believe that the implementation of European Social Charter in Ukraine and the case law of the European Commission of Social Rights that monitors the implementation of the Charter is unfortunately at the low level, and this case law is taken into account when monitoring the implementation of the ECHR, and we are now thinking of what needs to be done to improve the implementation of the European Social Charter. At the same time, it is extremely important that this Charter and recommendations of the European Commission of Social Rights and the decisions of this committee should be implemented better. And that these decisions are taken on board by domestic courts in Ukraine. Based on the results of the high-level conference co-organized by the Supreme Court and the National School of Judges, recommendations to improve judicial education were adopted, whereby the studies of the European social studies should be part, a charter should be part of the curriculum of judicial education institutions. And I can tell you that within the project of the Council of Europe, development of social rights of people as a factor for the sustainable democracy in Ukraine, we are now conducting a survey on the awareness levels of the Charter and case law of the committee by judges. And we are now planning to develop curriculum for judges on this topic in close cooperation with the National School of Judges of Ukraine. And we will be very glad to share the results of this survey with all of you. And we hope that the discussion today will be very fruitful and useful, and the situation with the application of the European Social Charter and case law of the European Committee of Social Rights will improve. Our office has been cooperating with the Supreme Court for a long time, and we would like to use this opportunity to assure you that we stay committed to this cooperation, particularly when it comes to the protection of social rights of Ukraine. Thank you very much for your attention. Thank you, Ms. Litvinenko, for your active participation, for the support, and for the welcoming address. Ladies and gentlemen, another support of this conference is EU Project Prava Justice. They've supported and cooperated with a lot of subjects of justice or actors of justice sector in this country, particularly the Supreme Court. And it is my great pleasure to give the floor to the Anna Adamski-Galant, key expert on justice of this project. Thank you very much, ladies and gentlemen. Ms. Denishevska, Justices of the Supreme Court, ladies and gentlemen, it's my great pleasure to greet you all at this most important event. I would like to say that it's great pleasure and great honor for us to cooperate so intensely and intensively with the Supreme Court. We do our best to support the best of their initiatives, particularly during the lockdown. We were very instrumental in organizing a number of events so that your your reach out is broad as possible. We invite international experts from Poland, from Austria, from Germany today. Some of them will be presenting approaches of their countries and of their judiciary to the protection of social rights. The role of independent courts and judges in protection and promotion of social rights of Ukraine is extremely important, and we will stand ready to further support these efforts. So I see that your program is very busy, and I won't take much of your time. But it's for the first time that I can see. It's for the first time that I can see interpretation into sign language during the conference, and I will learn from your experience and use it in our further events. I wish you good and fruitful work. Thank you very much. Thank you, Anna, for the welcoming address. Dear participants, another co-organizer is the German Foundation for International Legal Cooperation. This foundation and the Supreme Court has been in close relations for quite a while. It is with the active support of this foundation that we've conducted a lot of international meetings, roundtables, webinars, seminars, conferences. Mr. Stefan Holster was supposed to participate in this conference, but he couldn't make it for a number of circumstances. But we respect him and his organization extremely, and we welcome them and the experts invited by them. Now I will give the floor to a National Program Manager of the Rule of Law and Human Rights Program of OEC Project Coordinator in Ukraine. OEC PCU has supported a lot of our initiatives as well. So, Ms. Natalia Stupnitska, the floor is yours. Thank you very much, Mr. Rybachuk, esteemed President of the Supreme Court, esteemed justices, ladies and gentlemen, dear participants. It is my great honor to welcome you at this event that we support together with the Supreme Court, the National School of Judges. We see that there are a lot of organizations that also offered to support this event. Social rights are enshrined in a number of international European international law instruments, and without effective protection of social rights, the development of political and civil rights is not important, and the government and the parliament should provide for the conditions for the development of those rights. And the effective judicial protection is extremely important for vulnerable groups of the population that grow in number of late. And the challenges are faced in the context of protection of IDPs, those who suffered from the armed conflict in eastern Ukraine. And today we are facing new challenges related to COVID-19 pandemic. OEC does not focus on the protection of human rights per se, but our comprehensive approach to security allows us to address a vast range of issues, including human rights. OEC PCU cooperates with a number of partners to promote and to protect social rights. Together with the Ombudsman's Office in Ukraine, we hold expert discussions on access to justice, particularly in the context of the armed conflict in Ukraine. We discuss and prepare recommendations to different stakeholders on a number of topical issues, including compensations for the destroyed or damaged property as a result of the armed conflict, pension payments to people residing in the area of armed conflict, and also issues of ensuring social rights. Together with the National School of Judges and the Supreme Court, we develop curricula for judicial education institutions. I would like to avail myself of this opportunity to thank all the partners for this fruitful cooperation and wish you all an interesting discussion. Thank you, Ms. Stupnitska. Now we will pass to the first thematic area. And during the first section, we will be looking at the social rights and state legal mechanisms of their protection, including legislative regulation. In the second section, we will look at contemporary situation and prospects of the development of administrative judicial procedure regarding social rights protection. And we will be looking at case law in addressing certain categories of social disputes that administrative courts face. And the third section will be dedicated to procedural means of ensuring the effectiveness of justice in social disputes. And here we will look at very specific procedural measures used by administrative courts, including pilot case or pilot judgment and others, summative proceedings, etc. And I wish you could find the topic that is interesting for you and benefit from this discussion. Dear ladies and gentlemen, we will now have a 1-minute break, and I will give the floor to Mr. Semyon Stitsenko, Justice of the Supreme Court in the Administrative Cassation Court. He will be moderating session 1. Thank you very much.